This presentation is to discuss student records with the main focus being on protecting the student information. Student records can be defined as records that contain information directly related to a student and which are maintained by an educational agency, institution, or by a party acting for the agency or institution. Student records can also be called educational records or student files. In your student record, there are several things that can be considered to be a student record. Attendance is considered student record, and that pertains to number of days absent, excused absences, and unexcused absences. And under this umbrella, it also gets discussed the reasons for being absent, such as parent notes and doctor's notes. It covers grades, which can be listed as a transcript. It's also grades that are made on classroom assignments and teacher grade books, anything that has student information on it pertaining to how they are doing academically. This also includes standardized tests and how the students performed on that, whether they are listed as proficient or unproficient. All of this is considered student record. Discipline records are also student record, pertaining to the reason the discipline took place and the type of discipline that in the type of punishment that happened because of the misconduct. All of this is considered to be student record. Health records, any kind of illnesses, sicknesses, immunization records, shot records, and this really came into play with COVID this year, with school systems not being allowed to disclose which students were COVID positive and which students had been exposed. This came back to the health records and how that was a violation of student record. As we mentioned before, transcripts that contain grades that are official school information. And also included in this is financial information. And a lot of times we think of that being on a college level when we're talking about Pell Grants and any kind of financial aid that the student may be receiving. But this is also pertained to a student's free or reduced lunch count information on whether they file in that. I know that school systems are not allowed just to tell whether a student receives free or reduced lunch. There are regulations made by the federal government that help protect students, since student records contain so much of this personally identifiable information. There are regulations made to help protect these students. And the one that we most hear about in education is the FERPA Act. It is the Family Educational Rights and Privacy Act. It's a federal law that protects the privacy of student education records, and this law applies to all schools that receive funds under applicable program of the U.S. Department of Education. So basically, any public school that receives federal funds falls into this act. Another act that we don't think about school systems when we hear about the HIPAA laws, but it does include schools because we have so much health information on our students. It is the Health Insurance Portability Accountability Act. It was a law passed by Congress intended to establish the transaction security, privacy, and other standards to address concerns about the electronic exchange of health information. However, the HIPAA privacy rule excludes from its coverage those records that are protected by FERPA at the school districts and post-secondary institutions that provide health or medical services to students. So this pertains to student privacy and school record. If it's covered under FERPA, it's not covered in HIPAA. But a lot of times with HIPAA, it's just, we can't tell if a student has a medical need in our classroom. We can't share that information out, or we can't, share information when a student has been sick. And this really came back to play, like I said, in the COVID pandemic, where we had to be very careful about what information was shared about the student. And the last regulation that I'm going to discuss is the Children's Online Privacy Protection Act. And this does not necessarily um, pr- protect schools, but it's very important for educators to remember that of the requirements on the operators of websites or online services directed to children under the age of 13, and on operators of other websites or online services that have actual knowledge that are collecting personal information online from a child under the age of 13. And I included this in here because, in the digital age that we live in, we all have to be so careful that the online tools that we're using with our students in the online learning platforms, that they are not violating this Privacy Act, and they are not sharing our students' information, especially when they are under the year of 13, under 13 years of age. And it's just put into place to protect those students, where their privacy is protected and where we can keep our students safe. In the mention of the digital world that we live in, that comes with the concern of parents in protecting student privacy. A lot of the concerns of parents are the online learning platforms, and how information is shared through those platforms, the online school management programs. Um, Everything that we do in education now pertains to online. We put our grades in online, all of our student records are online. And that has been shown to be a concern of parents on how well those online platforms are being managed and the privacy that comes with those. Also, a concern of parents is who can access my child's student records at school. And it's important to note that only teachers and admin who have a direct interest and a legitimate interest in the student may access those records. Just because I'm a teacher at a school does not give me the right to access materials of a student that I do not have a legitimate concern for. I can't just go and access any of the students' records at my school. And also, a list has to be kept of who is accessing these records, what date they access them, and why are they accessing them. I know this falls into a lot of the time when we have IEP meetings. We have to sign out that we are looking at these records and why we are looking at them. And that list is kept at the school. If there is some in this Privacy Act, we have to understand that there is information that can be shared, and that the school or district may disclose directory information from educational records without consent of parents. Um, However, this consent they are notified, um, oftentimes through a student handbook or a newsletter, that we can share that information. Um, they can opt out of this, of parents can opt out of us disclosing this directory type of information. And this information could include the student's name, address, telephone number, um, their date of birth, where they were born, any kind of honors and awards that they received, and the dates that they attended the school. There are several hallmark cases when pertaining to student rights and protecting student rights and privacy. And one of these that I'm going to discuss is John Doe versus Gonzaga University. He was a college student that was in a teacher education program and was in the final stages of his program. And one of the teacher certification specialists overheard a conversation amongst other students of accusing this student of sexual misconduct. And without really, he did not speak to the John Doe, and without having more information, he launched an investigation, and he interviewed other students, and all of this was done without John Doe being made aware of these allegations. He actually had no idea that he was being accused of this until he received the affidavit saying that he was not going to receive his clearance to be a school teacher. Um, Therefore, he filed suit against Gonzaga University, and a court ruled in his favor and it awarded him the compensatory damages and punitive damages, and because they violated his claim, his FERPA rights by sharing this information about him. The next case is Jensen versus Reeves. And this was a very complex case that was difficult to narrow down where the student privacy violation took place. Parents of a student, that this student had several major incidents of misconduct. He had been accused of sexual misconduct, violence. He had had run-ins with teachers using negative language. There was just a case of misconduct on this student. And he was suspended from the school, and the parents' first claim was that due process was not followed. And in this claim, they claimed that the school had violated the student's privacy when the school system and the principal of the school notified parents of students that were involved in the misconduct. The principal had sent out a notice of the allegations and what had happened, and it was over one of the sexual misconduct cases, and the parents claimed that that is where the student's privacy was violated. The court dismissed these claims, and they dismissed them based on the nature of the incident, and that the parent of the victim had the right to know the outcome of the complaints that they had made on this student of sexual misconduct. So therefore, his FERPA rights were not violated in this case. The last one, the Osawatomie Public Schools versus Favon. This is where a case where the parents got upset over a peer grading taking place. They stated that it embarrassed their children for their peers to grade their papers, and because they would know how they were doing in class. And at first, the parents asked from the district that they make a policy that stated that peer grading had to stop, and the district did not agree with this. And after that, the parents filed a class action lawsuit stating that peer grading violated their students' privacy and their student rights. And after much discussion, the courts decided that the peer grading was not part of the student record until the teacher actually recorded them in the grade book. So therefore, peer grading did not violate this student's privacy.